For financial misconduct, the threshold is also obvious and gross. But compared to non-financial misconduct, the court is more willing and ready to find financial misconduct being obvious and gross. Typical examples of financial misbehaviors can include excessive spending, dissipation of assets in anticipation of divorce. These misconducts, if they are seen as wanton, reckless, or extravagant, then it would justify a reassessment of the distribution based on conduct. So wanton, reckless, extravagant, they are basically alternative to obvious and gross. In the context of financial misconduct. In the case of A and B, the husband is a barrister. He paid his girlfriend an amount of $1.2 million, and it was said in this case that payment to the girlfriend was wanton, reckless, and extravagant in view of the total marital assets of about $14.6 million. It was also gross and obvious in light of the marital standard of living. In that case, the parties have two flats, but they are adjacent to each other, and the two flats were converted into one, which was the matrimonial home. The husband has flat D registered under his name, and the wife has flat C under her name. The husband, in his proposal in the ancillary relief trial, the husband wants to keep flat D and only allow the wife and the daughters to stay there until the daughters reach 21. And then he offers to pay nominal maintenance to the wife and only $10,000 for each daughter per month. Okay. Think about this. You have two flats physically converted into one. The husband wants to retain one of the flat in the end. So he suggested that we put up a wall in the matrimonial home, and he has half. And he offers to pay $1 to the wife. And he's a barrister. And he argues all that in front of a judge. Okay? He claims, as a barrister, he makes a modest earning. His earning fluctuates at the region of $200,000 a month. And he says that he can't become a senior counsel or a district judge. A district judge earns about $160,000 a month at the time. And he doesn't know when he can be appointed to be a judge. So what he was saying eventually is that he's not making a lot of money, and the prospect of him having an increased earning capacity is very low or is very uncertain. And he was saying that to a district judge, saying that I make less money than you. Okay. If you do that, if you say that to a judge, judges get offended because they have many work to do, especially in the family court. And in the back of the mind of a family judge, they would think that barristers, lawyers, you can take as many cases as you want and you are earning way more than I do. And this barrister is presenting a case that I'm earning less than you, judge. Okay, so you have to think about how the judge was Bruno Chan. Okay, he was a very experienced family judge. And you have to think from the perspective of that experienced family judge how he thinks fairness should dictate the outcome of this ancillary relief. In the end, the husband was ordered to transfer flat C to the wife, so the wife would have flat C and D, the entire matrimonial home. On top of that, he was ordered to pay maintenance to the daughters at $15,000 each girl per month. Okay, so it's way more than what he offered in his open proposal. I also know that barrister. I know him personally, I know who he is. I can't tell you, but if you're nosy enough, the judge, I think, has really shown dismay at this husband. So the judge has exposed him enough that you would be able to identify that barrister based on the background information in the judgment. Okay? If you compare the judgment with the bar list, you would be able to locate that one guy on the bar list. That shows how much the judge hates the husband. And that's how the wife gets so much sympathy from the judge, okay, and gets a lot more than what the husband offered in his open proposal. Okay. So, if you have factual findings on financial misconduct, how is that reflected in the award? It is established in the Court of Appeal decision of ARAV and VP at the bottom of the slides that it can be done by way of notional add-back or departure from equality. Departure from equality, you know what it means. So the starting point is 50-50 and you adjust the percentage vis-a-vis husband and wife. Notional add-back is fictional. You don't really put more money into the pot, okay, because you don't factually have that money. So if there is, say, 10 million in the matrimonial pot, by 50-50, the husband and the wife would each have 5 million. If, for instance, the husband has dissipated 2 million in order to defeat the wife's claim in ancillary relief, then if the court is satisfied that there is financial misconduct, the 2 million, that figure, would be added to the equation notionally, mathematically. So the pot is hypothetically to contain 12 million in total, but factually it only has 10 million. Okay, but the court can assume by notional add-back that there's 12 million. So if you have 12 million, by 50-50, the wife would receive 6 million out of the 12 million. What it means is that in the end, that 10 million that you actually have, the wife would have 6, and the husband can only have 4. So in that way, it's not 50-50 of the 10 million. Okay, or simply, you don't need to apply notional add-back. You can simply depart from 50-50. It can be 55-45. Okay, it can be anything. Usually, you would get a bigger sharing by applying notional add-back instead of departure. Okay, because mathematically, you add a sum into that pot, notionally. In ARAV, it involves a long marriage. The parties were married, don't remember, 1908 or something. Actually, can't remember. It was a long marriage. The couple, they had a company with 2 major clients. They had a joint company with 2 major clients, and then the husband has another company with those 2 clients, and the husband is a 80% shareholder of his own company. The wife knew nothing about that individual company owned by the husband. So at some point, the joint company ran into some serious financial difficulties. The wife's case is that the husband has extracted a total of 32.5 million from the joint companies and injected that money into the husband's individual company. The husband said that the financial difficulties was simply because the two clients didn't want to do business with the joint company anymore. And the 32.5 million was not dissipation. It was just an aggregate sum representing the loans made to the husband's individual company to operate his business. It was at the family court level at first instance, it was a decision by Judge Malloy. The method she adopted was departure from equality, and she adjusted the award to just over 60% to the wife. Okay, so from 50% to the wife, she increased that to just above 60%. The wife appealed because she argued that the judge should have employed the technique of notional add-back instead of departure from equality. She wanted to add back the whole of 32.5 million. Okay. In this case, the pot amounted to 65 million. So if you add back 32 million, you would have 97. That would amount to 30% of an enlarged pool of assets. It's very huge. The Court of Appeal said that notional add-back is not automatic. It is just an option and is not the necessary result following a finding on financial misconduct. So there was nothing wrong with Judge Malloy's approach by simply departing from 50-50. Okay. So I think in this case, if add-back was actually allowed, then the result would be too extreme. So probably for the judge, it didn't feel fair to the husband if you add back that 30% to the assets. Okay, and there is nothing wrong to reflect that misconduct by adjusting the 50-50. After all, that's step 4 in LKW and DD. Okay. Okay, does it make sense to you? Litigation conduct, it refers to where you have acted unreasonably in a claim or for defending a claim. It is usually punished by an adverse cost order against a party who has litigated in an unreasonable manner. In ancillary relief proceedings, the principle on costs are the same as in civil procedure. So costs follow the event. And it depends on, the cost order would depend on whose proposals come closer to the ultimate result of the judgment on ancillary relief. But litigation misconduct can result in a cost order otherwise. So even if you have won in the end, you might still be punished by a cost order against you upon finding of litigation misconduct on your part. One of the examples of litigation misconduct is non-disclosure. Also, if you have repeatedly disregarded a court order, then it would also be litigation misconduct. On the other hand, so you have non-disclosure, but on the other hand, you don't want to have unnecessary or excessive discovery. That would also attract a court order against you. Okay? There is also misconduct like refusal to mediate or zealous litigation on a meritless point. Okay? If you're doomed to fail but you insist on running that point. The rationale behind a court order for litigation misconduct is that because of the way that you have litigated, the other side has no choice but to incur legal costs in seeking discovery or defending a point devoid of merits. Okay, or they would have to fight the case instead of settling it. That's conduct. And finally, on prenups, apart from conduct, you have to pay attention to all the circumstances. In fact, the list in A to G are part of the all of the circumstances if you refer to the statutory wording. The provision for all the circumstances is meant to be all-catching. And one of the circumstances would be the existence of a prenuptial agreement or a postnuptial agreement. The authority on prenups and postnups in Hong Kong is SPH and SA. Okay. I'm not sure if you have learned about this in contract, but long story short, in the old day, for policy reason, you can't have a marital contract. A marital contract is not enforceable as a matter of contract, traditionally, in common law. This has been challenged and changed following the judgment of Radmacher and Granatino. And in Hong Kong, Radmacher and Granatino was adopted in SPH and SA. Okay, so the overriding principle now is that the old rule that nuptial agreements are contrary to public policy is obsolete. Obsolete means it's out of date, it's no longer used. As a consequence, prenuptial and separation agreements are to be considered when the court comes to make award of ancillary relief. They are enforceable. The court is not obliged to give effect to nuptial agreements, meaning they're not binding on the court. The court does not have to give effect to the agreement, even though speaking from the perspective of the law of contract, it is enforceable. You don't have to give force to it. It cannot usurp the court's power in making a decision in ancillary relief. The principles enunciated in Radmacher should be regarded as the law in Hong Kong. In determining how much weight is to be accorded to the agreement. So basically, a nuptial agreement is enforceable as a matter of contract, but in a divorce, it's not binding in the court. It does not oust the court's jurisdiction. It is only one of the all circumstances in a case to be considered. So the short answer is that there is always a risk that you can't end your divorce, you can't end your marriage in your divorce with a nuptial agreement. It's not binding. So what are the laws in Radmacher? Well, let me tell you about Radmacher first. In this case, the husband and the wife married in 1998. They entered into a prenuptial agreement before the marriage. The husband was, he's a Frenchman. The wife is the heiress of a German industrial magnate, and there was pressure from the wife's father to protect the family wealth. The agreement, the prenuptial agreement, provides that neither party will make a claim upon the assets or income of the spouse in the event of breakdown of marriage. It was drafted 3 months before the marriage by a notary in Germany who has previously acted for the wife's family. The agreement was subject to German law. The husband was shown a preliminary draft of the agreement, but he declined to have independent legal advice, and he did not negotiate the terms. There was also no financial disclosure prior to the signing of the agreements. The parties subsequently separated in 2006. It was held by the Supreme Court, the UK, that there was no factor rendering it unfair to hold Mr. Granatino to the terms. Fairness, in this case, did not entitle him to a portion of the wife's wealth which she received from her family independent of the marriage. So the agreement was upheld. In the end, the husband was only granted provision for her role as the father for the two children and not for his own long-term needs. Okay. The law on marital contract completely changed by the UK Supreme Court's decision in Red Marker. If you want to know more about the considerations behind this decision, I believe there is a clip of about 40 minutes where the journalists interviewed the individual judges who sat and heard and decided Red Marker at the UK Supreme Court. And you get to hear the thoughts of those judges, those lords, in coming to this decision in Red Marker. I think it's available on YouTube. And I think if you go to the UKSC website, there might be a summary of this judgment on their website. Okay. Lady Hale was the only judge, was the only female judge, and she was the only judge that objected to prenup agreements. Okay. So the whole interview centered on this point of the difference between gender and whether it affects how they see prenuptial agreements. Okay? So what does it say in Red Marker? If the court is to give full weight to such a prenup agreement, then both the husband and the wife must have entered into that agreement of their own free will, without undue influence or pressure, and informed of the implication of having such a prenuptial agreement. The court would ask whether there was material lack of disclosure, information, or advice. Sound legal advice is desirable, for this will ensure that a party would understand the implication of the agreement. But this is not a necessary requirement, remember this. So I think your course manual is misleading in this regard. It's not necessary to have legal advice, okay? And this is demonstrated in Red Marker itself. And if you have legal representative, it will be desirable, and then full disclosure of any assets may be necessary to ensure that you make an informed decision. But if it's clear that a party is fully aware of the implications of an agreement and the party is indifferent to detailed particulars of the other party's assets, okay? If you know fully what the agreement means and you don't really care about what the other side has, there is no need to accord the agreement reduced weight because the party is unaware of those particulars. So disclosure is also not necessary, so long as you know what the implications of the agreement are. What is important is that each party should have all the information that is material to his or her decision, and that each party should intend the agreement should govern the financial consequences of the marriage coming to an end. So you need the intention that the agreement should be effective. That's just intention of contract. Okay. The second point is that when we talk about whether a party has entered into an agreement of his own free will, you don't have to resort to the legal terms such as misrepresentations or estoppel. The whole circumstances will be considered in the complex relationship of marriage. Okay? the first question you would ask is whether there are the standard vitiating factors, as you will find in contract, such as duress, fraud, and misrepresentation. Okay, whether any of these vitiating factors is present, and even if the agreement does not have contractual force, those factors will negate any effect the agreement might otherwise have. Undue pressure, even though it does not amount to duress, will also be likely to eliminate the weight to be attached to agreement. Okay? And also any situation of exploitation of a dominant position to secure an unfair advantage. That might also reduce or eliminate the weight to be attached to the agreement. Okay. And the court would also look into a party's emotional state or pressures that party was under in agreeing to that prenup. But that pressure is not to be considered in isolation. The circumstances of the parties at the time of the agreement would be relevant. Those would include matters such as their age and maturity, okay, whether they have been married before or in a long-term relationship before. Because if you have experience of previous relationships or marriage, then you will be able to foresee a marriage, and then you will have a different understanding of the agreement. You understand the implication of a marriage and the failure of a marriage. Okay. So as with a long-term relationship. Another important factor may be whether the marriage would have gone ahead without an agreement or without the terms which had been agreed. So these are the examples of all the circumstances you will consider. If the terms are unfair from the start, that would reduce its weight. The overriding criterion to be applied is that of fairness. If a prenuptial agreement deals with those matters in a way that the court might adopt absent such an agreement, there should be no problem giving effect to that agreement. Okay. The problem arises where the agreement makes provisions that conflict with what the court would otherwise consider to be the requirement of fairness. The fact of the agreement is capable of altering what is fair. In this case, the court would give effect to a nuptial agreement that is freely entered into by each party with a full appreciation of its implications, unless, in the circumstances prevailing, it would not be fair to hold the parties to their agreement. So ultimately, whether the court would give effect to the prenup would depend on fairness. Okay. Having considered all those things, all the circumstances. If the parties have had a very long marriage and by the time they get a divorce, the financial positions have changed drastically, that the parties are so much richer and they would not have envisaged that substantial change in their wealth, then it might be unfair to hold the parties to a prenuptial agreement. Then in that case, then the court might not give effect to that prenup. Okay? So these are the law on prenuptial agreements. They're not binding. It's only one of the all circumstances that the court would consider. Okay? I hope that answers your queries on prenuptial agreements. that's the end of these slides. I hope you have some takeaway from this lecture. But if you don't, for your exam, I think you're also safe. All you need to remember, I suppose, is Section 7 and LKW and DT. We still have some time. You have the facts for the mediation demonstration for next class. Do you want to know how I come to the husband and the wife's proposal in these particular facts? I can either do it now or I can do it in the next class. I think it would be better if I do it now because you just finished LKW and DT and you see how that is being applied. But if you're too tired, I can do it next time. Any preference? Do it now? Okay, give me, I think, 10 minutes. Have you got a chance to read the facts, firstly? Because if you don't, then you really don't have to sit and hear what I'm about to say, because you won't understand it. Yes. I might have to lose the mic because it's hard for me to hold it. So the proposals for the husband and the wife are at the bottom of the second page. Okay, and I'm trying to explain that part to you. The finance, the actual finance starts from the bottom of page 1. The first set of things you have is the matrimonial home. The matrimonial home is under the name of the husband. So, for the husband, you have the former matrimonial home. That is 68 million Hong Kong. You have, he has cash, 22 million. Okay, and that would include just cash of 12 million and 10 million of inheritance. Okay. These are the things under the legal name of the husband. For the wife, she simply has 6 million in cash. Okay. Okay. So that's basically step 1 of LKW and DT. That in total would be 26. So the pot, this is the whole pot. Can you all see that? Because the pot is a bit wide. You all see that? The wife has an argument of financial misconduct on the part of the husband. That's the paragraph of the second page. About the watches of the husband. It says there is 8 million. Of 8 million that is either not disclosed or have been dissipated. Okay. So for the wife to maximize her case, she would ask for notional add back of this. So with notional add back, the whole very short marriage. And it is not very helpful if you capitalize the parties' needs for what you need from this point of time until you die. Okay, it's only a 5-year marriage. The easiest way to look at whether sharing can be applied as in step 3 is by looking at the parties' respective income and the table of expenses. Okay? The table is something that you will find in the Form E. So for the husband, his monthly income is $240,000 Hong Kong. The wife is making nothing as of now, but she was supposed to have a very high earning capacity. Okay, so presumably, well, she's also relatively young. I didn't say what career she was in, right? Oh, she was a banker. Oh, yeah, she was a banker. So I suppose she can go back, after a few years' time, she can go back to work in finance or other capacity. She would have some sort of earning capacity. You can expect that, especially in such a short marriage. So right now, the whole earning capacity of this couple is $240,000. If you look at the table, the husband's monthly expenses is $81,300, the wife $50,500. The total is $131,800. So on the husband's income alone, both parties' needs will be satisfied. Okay? The expenses are monthly, the income is monthly. So the easiest way to look at whether sharing can be applied is by looking at expenses and income. There should be no problem that there is sharing pays. So you get to share this amount of money, the 96 million. In the wife's case, she would try to argue 104 in total. If you, in the wife's case, if you use 104 as the pot, because you add back the watches, then 50% of this will be 52 million. Okay, for the wife, 50% will be 52 million. But in the end, because she has 6 million, what she would get is 46. That's for 50% sharing. If it's 50-50. But the wife is asking for 65. 65 of this amount is 67.6 million. So if you discount the 6 million that she already has, it should be 61.6 million. And she rounded down to 60 million as what she will receive from the husband. Okay, does it make sense? And that's the wife's proposal. Does it make sense to you? Don't forget about the 6 million, because it's under the wife's name already. You have to do the deduction when you make the offer. For the husband, obviously, there is no such thing as the watches, the 8 million. It does not exist on his version of the balance sheet. And also, he will want to take out the inheritance because it has nothing to do with the marriage. Although, in this case, the inheritance was received during the marriage. Okay, so it's arguable that the husband might have used part of the inheritance money to maintain the wife, because he has been maintaining the wife throughout the marriage. So whether this would be taken out is a matter of fact for the court to decide. But for the husband, in his proposal, he would take out this part.
husband's case, the pot would be this, which is 86. That's the pot in the husband's case. In the wife's case, it's 104. Her best case, his best case. And if 50% of this is 43 to the wife, and you deduct the 6 million, then the wife would get 37. If 50-50, that's the starting point, okay, in FAW and DD. That's 50%. But the husband offered only 30%. 30% is 25.8 to the wife. So if you deduct the 6 million under the name of the wife, it's 19.8. And the husband rounded it up to 20 million. Also childhood. For some judges, such as Judge Malloy, Judge Ivan Wong, Judge George Owen, for these judges, they might see a marriage under 5 years without any children as a short marriage. But in modern day, for me personally, I will argue that this is not long, but it's not short. 5 years is already very long in these days in Hong Kong. But I think legally speaking, I will argue that this is not short, not long. For the husband, he would definitely argue this is short in its classic sense, because it's short in length without children. So he offers 30%. For the wife, she asks for 65% because of the non-financial conduct. She says that the husband was in affairs with many women. She was pregnant and then had that discovery, and that led to a miscarriage. As I said, it doesn't really affect the percentage of sharing. Definitely not to that extent. But these facts of a miscarriage would go to the judge's sympathy. The judge is likely to award slightly on top of 50% to reflect that non-financial conduct. But it is highly unlikely that will be 65%. There is also the element of compensation for relationship-generated loss. But as I said, it would not be a lot. It certainly would not be 15%. Okay? Maybe 5%, something like that. Okay? But that's how the wife would maximize her case, and it does not take into account of the short marriage, the length of the marriage, which is, I think, is the key factor in this case. Okay? And also, you don't have to, in ARAB, you don't have to add back. So the plot might be just this, and not this. This is based on notional add back. If you don't have notional add back, then 65% of especially in face of the strong factors that it's a short, childless marriage. Okay? And the majority of the wealth is held by the husband. So the likely outcome, if these facts go to trial, will sit between the husband and the wife's proposal, maybe closer to the husband's proposal. What do you think might be the likely percentage? Any views? This is an open question. There is no answer. I made it up. Okay. It's not a real case. I made it up. I think in the end, if I was the judge, I would use this as the basis of the court. Okay, if it's in a settlement situation, forget about the watches, and then forget about the watches for the wife, forget about inheritance for the husband. If you do it on a broad brush basis, the court will be this. And I will probably use a 40% or 45% in favor of the wife. Because it's a classic short marriage based on his law. Okay? Because for the wife to argue for the watches, she needs some strong evidence, financial evidence. And on the affairs and the miscarriage, it doesn't really do much. Okay? Even with the loss of career. Because for a short marriage, maybe 35%, and with a little bit of sympathy to the wife, maybe 40% to the wife. If 40% of 69, that will be 38.4, and you deduct the 6 million, it's slightly more than 30 million, 32.4 million. In fact, if you look at the needs of Cecilia, she claims about 50,000 a month. 50,500 a year would be slightly over 600,000. And she would be, let's say the marriage was 5 years, to give the benefit to the wife. If you times that annual sum by 5, it's about 3 million. So if you look at the needs of the wife, you argue re-establishment of the wife, that would be about 3 million to the wife to help her re-establish. And if you take this sum and use 40% and you deduct that 6 million, it's more or less 30 million. More or less the same result by coincidence. So I think somewhere around 30 million, that region, would be the fair result of these facts. Okay, any questions? because I have a mandatory professional training for me to become a fear prosecutor. I have to do that training in 5:30 to 7 in Singapore. So that means that I could be running late to this lecture, just so you know. But in any event, because we schedule for 7 to 10, I suppose we can start no later than 7:30. Okay. Well, of course you're welcome to come in early, but just that you probably won't see me at 7 sharp, because I have that training in Central. But the lecture would not overrun. Okay? And I know that you have an assignment. Final problem. I'm giving you that leeway by doing APR on next Monday instead of Monday. Okay? Is it cool? And the mock mediation again will be conducted in Cantonese for the benefit of the volunteers.